Hello, everyone. My name is Daniel Valdez with Celeritas Digital, and welcome to our monthly peer discussion. We have a great turnout today, thanks to the wonderful choice in topic, courtesy of Laura and Christina here, who I'd love to introduce. They are our facilitators for this conversation on GDPR pitfalls in veterinary practice and how to deal with them. And I think we're going to have a really well-rounded discussion based around a number of questions that came in from a lot of you in the audience here, and from people who came across the invitation to this discussion. So without further ado, I would love to introduce first Christina Vanini Goodchild, who's the managing director of CVG Solutions, a multi-award-winning GDPR expert, and Laura Shaw, development consultant with Training Progress. And I look forward to hearing you both share some valuable insights on GDPR pitfalls and how to deal with them. So without further ado, Laura and Christina.
Hi, Christina, do you want to go first? My name's Laura Shaw, as you said. I'm from Training Progress. I'm a veterinary surgeon, and I've been out of clinical practice now for about 8 years. But prior to that, I worked in a number of roles in the UK and New Zealand as mainly small animal veterinary surgeon, and I locum work. And I also had some management responsibilities in my roles. And like I said, about 8 years ago, I left clinical practice and joined Training Progress as a development consultant, so helping develop programs to make it really super useful for veterinary practices. Christina, do you want to say a little bit about yourself?
Yes, okay. So I'm Christina. So I'm originally from Italy, but I have been living in the UK for a number of years. I've always worked in large corporate organizations as senior management roles, and always been involved in data and governance, compliance, best practices, methodologies, etc. And then 4 years ago, I started my practice because I wanted to help small businesses with the GDPR, because it can be quite daunting. It can be quite, it's never black and white. It's very always grey. So I felt that I could give all of my expertise and knowledge to help small businesses, of which primarily veterinary practice usually are, not always, but most of the time they are. So yes, and so I'm here today to share my knowledge with you.
Wonderful. Okay, I'm going to give you guys permission to share so that you can begin presenting some of the basics first, if you'd like. I know you were going to introduce the basics of what GDPR is in the first place to start. So I would love to hear more about that.
Yes. So, okay, so I'm just going to share, and then I'm going to go on this. Right. Okay, so Laura and I have prepared a couple of slides to share with you, just to make sure to bring everybody on the same page. So one of the things that I wanted to clarify is that, because I believe we have, in the audience, some people that are not UK based. So the topic of today is the UK GDPR. So if you're not UK based, if you're in the States or any other part of the world, it would be still interesting to you if you have, for example, intention of expanding your practice and have UK branches, or if you have employees in the UK or clients in the UK, these will still be relevant to you as well. So one of the key basics of the GDPR is what the GDPR calls a data subject. So what is it, or who is it? So is it, a live individual? Is it someone who unfortunately is deceased? Or is it, an animal or a pet? So actually, it's the living individuals. So the GDPR scope is only about living individuals. So there are other regulations that deals with animal welfare, animal rights, same with disease. But from a GDPR perspective, what it is in scope is just living individuals. So I thought that clarify that, because we received some of the questions where this comes in is quite key important. The other thing that I wanted to share with you is that you're going to hear me talking about using the word processing a lot, processing the data. So what does it actually mean? And every time I ask that question, the answer that I always get is, well, it means using the data, surely. Of course it does, but it also means a lot of other things. So it means also sharing and disclosing it, collecting it or storing it. It means adapting it, combining it, consulting it, altering it, retrieving it. So if you're downloading it, for example, you are processing the data, and including destroying or deleting it. So if you're doing any or all of these activities, it means that you're processing the data. Obviously, for data, I'm referring to personal data. Okay, so so I just wanted to have these to clarify that, because you're going to hear me saying that word quite often. I also wanted to just kill some mythbusters that are out there. So one is, I'm registered with the ICO, therefore I'm compliant. Actually not. So ICO, for those of you that don't know, is the Information Commissioner Officer, who is responsible, who is the regulator of the GDPR in the UK. So the registration is just a tax. That's all it is, and nothing more. So that does not make you compliant. There's a lot more that you need to do to be compliant. Our software is fully compliant. So I've got some bad news. The software does not make you compliant. Is what you do with it, is the purpose of how you use the data, why you're using the data, that determines the compliance. Another one is our data is fully GDPR compliant. Again, there is no such thing as a GDPR compliant data. Is the purpose and what you do with it, okay, that makes it compliant. We have all of the security measures in place. We are fine. You're not. So security is important, and perhaps the name of the regulation, because it's it stands data protection, can be a bit misleading, because actually there are 99 articles in the regulation. Only one is about security. The regulation is based on 6 principles. 1 is about security, and 5 are about purpose. So that is what you need to remember. So no, I'm not saying security is not important. It is, but there is a lot more to the regulation, just security. And then the final ones is we're only, we're B2B. We only have business email addresses or telephone numbers, so it doesn't apply. Well, actually it does, because if the business email address or the business telephone number is directly linked to the individual, then it is personal data. So unless it's a switchboard or like a mailbox, but if it's got a name or if it's directly linked to the individual, it is personal data. So I just wanted to put these on the table so that we're all on the same page as we move forward. Laura, over to you.
Thank you. So I just wanted to sort of get us onto the same page about what are those data processing activities that we do in veterinary practice. And this is by no means an exhaustive list, but I just thought I'd sort of bring our mind to something. So we need to consider the way that we're receiving data. So that might be a newly registered client, or taking a message and taking somebody's name and telephone number down. We may have contact pages from our website or social media. We have collect data about our team members. So we have a new person starting, you're going to have their contact details, their bank details, next of kin, all that stuff. That's data. And also we work with other people, even if they're businesses. We might have the direct telephone number of the lady who runs the Cats Protection League, or the local dog pound. So these are, as Christina says, that even if they're business numbers, it's still personal data if you're getting directly through to these people. There are all sorts of other processing activities that we're doing in practice. We have consent forms and printed materials, invoices and things that we have around. We might be checking data regularly with clients. We have to deal with referrals and second opinions and transfer of clients to other businesses, and that may involve the client's data. We also have to deal with insurance companies or online pharmacies, and that might involve some data. And if we're doing research, we have to be careful. Are we looking at data for that, and do we have correct permissions for doing that? And also, sort of lastly, we need to look at how long we're retaining data. If a client has left you and gone to another practice, how long should we be holding on to that data? So these are all things that within our vet practices we need to be aware of. Next slide, please, Christina. Thank you. So really important to know your processes and everything really that you do within your practice. You should have some processes so that your team members are working consistently, but also, if you've got processes for how you're registering a client, what you're doing with data that's coming in from different places, that makes your life an awful lot easier when it comes to creating a data map and a register of data processing activities, which are really useful at creating a data inventory. And data inventory is one of the things that you do need. You need to know what data you've got and what you're doing with it. There are also specific processes and protocols that you should have, such as a data subject access request process and data breach processes as well. Now, these can be a little bit kind of daunting, all these kind of different processes and things that you've got to have. And a little plug for Christina, she's certainly helped us and a lot of other businesses as well with, she's got a toolbox of a lot of these kind of this content and processes and things that you need. So maybe worth if you're thinking, oh God, they're talking about lots of stuff, I don't know what they are, and it's making you panic. Don't panic. Maybe reach out to Christina afterwards and she may be able to help with that. Next slide, please, Christina. And this really just goes into kind of where training progress fits into, why am I here? So if we have all these processes and you're also one of the things that you're required to do for training progress, so for GDPR is to train your team in GDPR as well. You need to make sure that those processes that you're creating, be they just the ones where you're working through sort of daily or your specific GDPR processes, your team need to have accessibility to that. It's no good it being on a dusty shelf in the practice manager's office. You actually need to be able to access them. They need to be easily updated, so that when you're improving your processes as part of a continuous improvement process, that's easy to do, and again those changes can be shared with your team. And again, as part of your training and GDPR training, you need to be able to schedule that, and also you need proof of trading for GDPR. You need to show that actually, again, these things aren't just sort of locked up on a written processes on somebody's hard drive, but then actually you shared them with your team, you trained your team in it, and you've got proof that they've got training. And that was my bit. Thank you, Christine, and we can move on again. Lovely, awesome information about us you can peruse while you're listening to the questions. We have been really lucky. Lots of you got in touch with some questions that you wanted to know about GDPR, and I'm going to do my best to put those to Christina. We may not have time for all of them, but we'll see where we get to. So Christina, you ready?
Yes, go on.
Right.
hit me with it.
Hit with it. So the first question is, the person who presents the animal is not always the client. It may be a dog walker, a relative, or a neighbour. But the consent form, which we're going to produce and get them to sign, has got the client's data on it. Is that okay for them to sign and to take away the copies as usual?
Okay, so I think there is different elements that we need to consider here. So first of all, the person that is coming with the animal that is not the owner, are they authorized on behalf of the owner to sign the consent form? Because otherwise that would be invalidated. So if they are authorized to do that, and it should be on your record, then yes, you can. So if I give my own personal example, so I have a horse that is stable at a yard, and I have instructed my vet that the yard owner can contact the vet in case of emergency, and she has my authority to deal with the vet, and so on, if I'm absent, for example, or I'm not around. So that's what I've done. So that's what I would suggest. So the vet can share with her that data. So it's the same, for example, if you think about when I have, like many of you have, we are registered for the electricity and the gas, and I'm the main principal contact, but I have also said that my husband is the second contact. Now he's the primary contact, for example, for the telephone, but I'm the second. So that means that the electricity and the telephone organization, they can talk to me or my husband, whoever is the second. So it's the same principle in the case of an animal. Yeah,
that's super. Yeah, I just wanted to put a little bit of vet context to that as well. So the RCVS Code of Conduct talks about the owner or the client may be either the owner or someone acting on authority of the owner. And practice staff should ensure they're satisfied that the person giving consent has the authority to do so. So there is mention of that in the RCVS Code of Conduct as well. So that fits perfectly.
Yeah.
All right, question 2. What can we put in the records or notes about owners' medical and financial information? For example, if the owner is immunocompromised, I want to make a note that the kennel cough vaccination was recommended against. So, Christina, yes, there are certain medicines that you wouldn't want to give if the owner is their immune system is compromised. Yes. So this person is asking kind of how to deal with that.
So okay, so this is where vital interest kicks in. So obviously it is in the interest of the client, the human, to make sure that their health is not compromised. So so vital interest kick in, so you can record that into the note. What I would recommend or suggest is that to have separate notes for the animals and the humans, so that they don't come into contact with each other, and perhaps sort of and have a process to support that, to sort of instruct the medical team or the staff that they need to look at both notes before administering any drugs or any vaccination and so on. If you can, if your practice system allows you to keep the notes separate, that would be the best way forward.
Yeah, actually I did I spoke to a representative from ProVet, which is one of the practice management systems, and they said that that they have separate places where they keep the client details separate from the patient details, and there's a separate little section where you can put kind of client notes. So that would include financial notes as well as medical, would it, Christina?
Yes.
Yeah, lovely. And again, that kind of that does go with the Royal College Code of Conduct supporting notes as well. And they suggest that client financial, personal and sensitive information should be recorded separately. It is, however, accessible to include a statement that treatment has been limited or declined for financial or other reasons.
Yeah.
Lovely. So this kind of relates a little bit to the first question, actually, this one. We have a few clients with learning difficulties and dementia. Their relatives or support workers often bring the animal in. They will then be handling the paperwork, and it's got the client's data on it. Is this okay?
Okay. So, usually in the case of disabled individual or dementia, the person that is looking after them, they have a status of guardianship, and they usually there is a sort of a legal document that proves that. Certainly support workers will have that. So as part of your onboarding of that client, I would ask personally to see the document, because you need to satisfy yourself that they are authorized to act on behalf of the client. And then perhaps sort of make a note of that in your filing system, so that you don't have to see that or ask for that every time. But the first time I will certainly do that. So once they have the authority, or they can demonstrate the authority, then yes, they're acting on behalf of the client, so you can share with them the data.
Great. Okay. So this one is about says we're concerned about cases of non-accidental injury to an animal. Can we put this in the clinical notes, and are we allowed to discuss our concerns with a referring vet practice, RSPCA or police? Okay.
So obviously the patient is the animal. So as we saw earlier in our slides, animals are not in the scope of GDPR. So if it's the animal welfare that it's a risk, then the GDPR will say, go ahead, because it's not within our scope. There might be other regulations that will allow you or not to share the data. I'm afraid that's not my area. So we'll see what the Royal College says on that. But again, if you suspect illegal activity, so causing cruelty to an animal, it's illegal. So you should report that. You should record that. So the GDPR does not prevent you from doing that, because again, you will be acting under legal obligations. So you're legally obliged to report the crime, which includes, animal cruelty.
That absolutely corresponds with the RCVS, and I just picked out a little nugget from the supporting notes, and it says confidentiality is not absolute, and that GDPR is not a barrier to reporting concerns and suspicions to the appropriate authorities. So that fits very nicely with your answer. I feel a bit like a quiz show host. You don't get a big prize at the end though, Christine. So how often do we have to update information kept for marketing purposes, and how long can we keep it?
Okay, so it depends what marketing information you're holding. So again, I'm guessing you're talking about like on a mailing list, if you're having a mailing list where you are regularly sending them newsletters or email promotion. So again, if the way you have, if when you added the individual contact details to the mailing list, whether you've done it correctly, then you're fine. But one of the requirements of the regulation is that data should be kept up to date. So you should endeavor to do that. So if I give you an example, so for example, when I go to my dentist, every time I go, they check that my data is still valid. Okay, so you don't have to do it that way. You could, for example, once a year, send an email out to your clients just to say, has anything changed? My bank, for example, they send me notifications from my online banking to say, please go into your account, and check that your email, phone numbers, etc. are still correct. So you could do it that way. So that's one thing. In terms of the retention, so this is goes back to what Laura mentioned earlier on, that you have to have how long are you going to retain the data? So you need to have a data retention policy. that basically clarifies and specify how long you need to keep a certain type of data for, and you need to look into various elements. So, you know, financial data, for example, you need to keep for 7 years, so that it's the law that imposes that on you. You know, emails, there isn't any, you know, there's no data, or there's no law, sorry, that sort of says you've got to keep it for a particular amount of time. It's up to you. If you want to keep it for 10 years, you can, but you need to justify. So what the GDPR says is that you should not keep data for as long, any longer than is necessary. So you need to justify it for how long you want to keep it. So in some cases, the justification is, I have to comply to specific regulation or specific legislation. Some other time is a business need. So that's really the bottom line for that.
Brilliant. No, that's great. Very good answer. Can we ask clients for ID, and can we keep this on file? I think when we maybe want to ask someone for identification, I suppose
well, sometimes you have to ask for IDs when it comes to subject access requests, for example.
Okay, yeah.
So that could be, you know. So so I was, again, going back to what I said earlier, that is not data that makes you compliant, is the purpose, of why you're using it. So I would then say, you know, what is the purpose for asking for IDs? You know, is it because you're trying to determine that individual is the authorized individual, like someone is acting on behalf of someone else, for example? So, you know, you can, but again, everything needs to be proportionate. So, you know, is it really proportionate for you to ask the individual to produce a copy of their passport, or give you their passport for you to take a photocopy, for example? Or can you achieve the same outcome but in a different way? So, you know, instead of asking personal data, can you ask, for example, only something that you and the person would know? For example, the pet's name, or the pet's age, or the microchip number, or you know, if the, you know, what illnesses, you know, that the animal has, or treatment they're under. So just something that you know, without asking the personal data, because that's the personal data you collect, the more there is, the higher risk for you. Because you have to then have additional requirements in place.
Presumably, you could ask to, if you needed to see, you know, specific identification, you could ask for that, but then not store it, and just have a way of saying, you know, that I saw their passport and it looked like them, or something. Would that be adequate?
Yes, you could, but again, it's proportionate. So one would see that, you know, we're talking about, it's not like I'm trying to access my, you know, a bank account. It is about an animal. So you put out
earphones, something.
No.
Yeah, go and get some earphones.
Can't put them on here, can you?
Oh yeah, Daniel. Oh, that's right.
Sorry about that. And
your sound went a bit crackly, Christina. I don't know if you can give your microphone another tap.
So the ID needs to be proportionate to the purpose. Okay. So asking someone to show you the passport when it's in relation to an animal, you know, a pet, is probably not proportionate. Okay. So it's a different thing if, for example, we're talking about a child. Because they're vulnerable. Okay.
Cool. Now you get a few moments breather on this one, Christina, because we've had quite a few questions relating to how to determine the ownership of a pet. For example, if the microchip is got two names on it, and you know, the couple have split up, or if one person has the pet and but there's somebody else is registered on the microchip. And I spoke with Christina in advance, and this is not a GDPR question because it's about an animal. I've learned something. But I did speak with IdentiPet, who gave me some really helpful information. And seeing as this came up quite a few times, I thought I would share a précis of what they have said. And this obviously relates to their processes. So the first thing that they have said, that ideally you should only have one person named on the microchip. That's one of their policies, but obviously sometimes other people are filling those in, and somebody else might have put more than one person on there. And the second point is that microchips do not, they relate to who the keeper of the animal is, and they're not proof of ownership. So just because a microchip is in there and says that it's owned by Mrs. Jones, it does not mean that Mrs. Jones is absolutely the owner, okay? So if you have somebody come in who wants to change the who is on the microchip, so who the keeper is officially, they have a sort of a big long process as to how they obtain that. Like I say, what the microchip is relating to is who the keeper is. And that's the part of the legislation is that it should be registered to the keeper of the animal. And so what they will do is they will contact the registered keeper, so the person who's already on the chip, by phone and also by email. And then they have sort of 14 days for them to get back to them. So but often people change their mobile numbers, they don't keep these things up to date. And if they don't get back in touch with the identity chip after 14 days, then it's automatically then transferred to the new keeper. If the old keeper refuses to have that keepership transferred, then they need to provide evidence that they are actively trying to get the keepership of the animal back. So that would be something like evidence of a police investigation, or evidence from a professional body such as a solicitor or a vet to confirm that it's an ongoing court case. But basically, if they are unable to sort of to prove that, they've got 6 months, and if it's not settled again, that the keepership will be transferred to the new keeper. Or if there's two owners are registered on the microchip, then what they'll do is you as if you're the person trying to prove that you're the new keeper, you need to provide evidence of keepership. So that would be maybe that could well be a letter from the vet saying, I've been dealing with Mrs. Jones for the last 2 years, and she's always the one who brought the dog in, therefore she appears to be the keeper. So I thought that was really interesting. It's not GDPR, but everyone wants to know about it, so I hope that's helpful. That information was précis, and I hope I got it right. That was from IdentiPet, and I'm sure you can contact them directly if you want any more information about that. Right, Christine, you're back on. So please explain the difference between the allowed content in a service message and a marketing message, and the legal basis broadly applying to both.
Okay, so
Christina, we can't hear you. Can you no,
Connection's a little rough.
it's a bit crackly.
Still a little distant.
Only just. Well, there you go. Something's happened.
Okay, can you hear me now?
We can hear you. Yeah, just maybe speak sort of slowly, because it's got a little bit of a crackle. Thanks, Christina.
Okay, so a marketing message, it's a message that it's promotional in nature. So if you're promoting a service or a product, or if, for example, you're asking them to sign on your newsletter, which you shouldn't, that it's promotional in nature. A service message is part of your providing service. So it could be, for example, my vet reminds me when my dogs are due for their flea treatments, for their vaccination. So it's about the service. They're not promoting anything, they're just reminding me. So that is the service message. So in terms of the legal requirements, is that you don't need consent or anything for the service message. For the marketing message, you need to follow specific guidelines, which is under not the GDPR, but the PECA regulation, which is the privacy electronic regulation, data regulation. So you will need consent in some cases, well, especially if you are a B2C, so business to consumer business, which primarily most veterinary practices would be, because you're dealing with the consumer. So you will need consent for you to send them marketing material. And the way to obtain consent is not to send them an email to ask for their consent to marketing material, because that in itself, it's promotional in nature. So you could do that, for example, as part of your onboarding process. You could ask them whether they would welcome, to receive promotional offers, information. So, preferences on how they would like to receive that. Is it by text? Is it email? Is it in the post, for example? So you could ask, obtain consent that way. Yes.
So a service message would be, Mrs. Vanini, good child, your dog is due some wormers. Would you like to come pick some up? But
yes.
And marketing would be, we've got some fantastic new dog food in. Would you like to try some?
Yes.
Okay.
Absolutely. Yes.
Can we call another vet practice to discuss a patient if the client has come directly to us? So this sounds like somebody seeking either a second opinion or transferring between practices. They're sort of coming directly to that person, to the new practice, without having informed their own vet practice that they're moving.
So okay. So again, for patients, we're talking about the pet. So from a GDPR perspective, yes, you can. And also in terms of the client themselves, so the human, let's say, they are the one coming to you. So, they are sharing the data with you. So that's fine. So yeah, so it's just that what we've got to remember in the veterinary practice is that the patient is the animal, which is out of the scope of the GDPR. The owner is human.
I will mention a few things that our CVS says on that, but so that which absolutely correlates with what you're saying. So they said that sort of client consent to pass confidential information about the animal is not personal information. It may be express or implied, e.g. the client leaves practice or insurance company is seeking clarification. And the other thing that they sort of talking about is that veterinary surgeons should not knowingly take over a colleague's case without informing the other veterinary surgeon and obtaining notes. And animal, when an animal is initially presented, yeah, absolutely. They should ask if the animal is already receiving attention and treatment, and contact the original vet for a history. Make it clear that it is in the interest of the patient, and if the client refuses, the case should be declined. So actually, the Royal College is sort of saying that that you shouldn't be kind of taking on clients if they're refusing to allow you to do that. One thing that did come up in my conversation with the guys at ProVet is, again, that there is ways of sort of redacting information. So if you're asked to transfer patient notes for to a new practice, if you've got your consent to transfer the notes and everything, then that's great. But actually, you can. There are ways on the practice management system to sort of cleave off between the patient notes from the animal notes. So you should be able to send information about Fluffy, and Fluffy's an 8-year-old domestic short hair, and information about that without saying that she's owned by Mrs. Jones of 46 Acacia Avenue. You know, you should be able to just separate that information.
Yes, so again, we need to be considering that, you know, if say, for example, I'm moving my dogs from my current vet, and I am suffering from you know, a low immune system, so my current vet should be informing the new vet of that under the vital interest, because otherwise the new vet could be prescribing, saying the kennel cough, and then I could then my health will be jeopardized. Yeah, so we got to remember that.
Okay, so you had a bit of a crackle on that first bit. So you're talking
Okay.
about that's okay. Yeah, don't move. It's perfect now. Where you're transferring, and so if you've got those medical notes that say that you know, we do need to be being careful with this client, that's vital interest, and that can go.
Yeah, so when you are making the notes, you don't have to say the owner has cancer, you know, and is undergoing chemotherapy. You know, the notes can be vague. The notes can simply say that, you know, the owner has a low immune system. Do not prescribe or administer live vaccines or live, you know, so it could be as simple as that.
Okay.
And that piece of data from when transferring from one vet to another needs to go to the new vet, because that is vital interest. Yeah. Okay. So the new vet needs to know that.
That's brilliant. Right. This one is this is a really big one, Christina, and I think we might need to, you know, cleave this one down a little bit, possibly referring people onto other things, because it's what do we do in the event of a data breach?
Okay. Okay, right. We might need to have Daniel. We're going to have a separate session just on data breaches. Okay, so there is a specific process that you need to follow when it comes to data breaches. In very simple terms, the first thing you do is you need to record data breach in a log, in a register. So Laura earlier on mentioned that I have a toolkit. So that toolkit contains that process, contains the register and other bits and pieces that you need to manage this process. The breach needs to be assessed because you need to understand the severity, if it's a high severity or low severity to the individual, okay? If it's a high severity or high risk, then it needs to be reported to the ICO, the Information Commissioner Officer, but also to the individuals impacted. Otherwise, you don't need to do that, but you need to keep a record of them, you know, for your own benefit, for audit trail, audit purposes, for analysis, so you can understand over time in your trends, what are the causes of your data breaches? Is it, you know, is it always the same department, the same individual? You know, so you need to perhaps you need to do some more in-depth training, or you need to change some of your processes to remove and avoid that data breach happening again. So this is very high level, very simple terms, but that's what you need to do.
Great, okie dokie. I know this one came up a bit as well, actually. So this person was saying that they've got paper consent forms which, you know, which get signed when the patient comes in, and then that you know, the consent form then kind of follows the animal around the hospital. They're sort of attached to the front of the kennel, and then, you know, they sort of move around with them around the building. Then they get put in a pile in the nurse's office to be filed eventually. So obviously in that situation, you've got that consent form with the personal data kind of hanging around and not necessarily under lock and key. Is that okay?
Okay, so so obviously, you know, data security is important, and it's not just about technical, you know, cyber security, you know, your technical security is also physical security. So if that data, you know, I know that it's not always possible to file a document immediately, okay, especially in an environment like a vet where you have emergency coming in. So always make sure that this paper data or data on paper is not kept in reception, because there is a lot of traffic in reception, for example. But you know, if it's in the nurse's room, is that room locked? You know, so only authorized personnel can go in. Then yeah, then it's not ideal, but okay, you know, it is what you can do. Make sure that you give your staff to do the filing, so that you don't have months and months of paper, you know, because again, the more you have, the more risk. Yeah. So make sure that you allow the staff to do the filing. So yeah, keep that data as much as you possibly can in restricted areas where only you know, authorized personnel is allowed, and avoid the open spaces like the reception or the waiting room, and you know, those kind of places.
Okay, cool. That's great. And presumably, if you've got the facility to avoid that, I know sort of again on the practice management systems, we're talking about e-sign situations and things. Is that going to be that would be a bit of a boost, wouldn't it? Yeah. Yes,
that would be ideal. Or you could have that, you know, if you need to do the paper, scan it maybe, and then you can then destroy the paper, you know, shred it. You know, that could be another way of doing it.
I guess it's about convenience as to, you know, getting hold of that bit of paper. You know, if I need to know Mrs. James's mobile number now. But I guess you could, you know, if you have better access to your client notes and things in different places, then that would sort of get around it. And they do, you know, sort of electronic whiteboards and things is something that practices have are starting to look at nowadays. But I think that that sort of thing might help, mightn't it?
Yes.
Yeah. Lovely. Good. So this question was sort of, you know, asking about the practice management system, and can it be used to manage contact preferences and other GDPR issues? So a practice management system, Christina, is like a client management system, or have we got any thoughts on you know, obviously you don't know the ins and outs of the practice management systems, but is there any things that you would think that you would maybe, if you were going to get a new practice management system, what might be your GDPR wish list on that? It's a really difficult question. But what sort of things do you think you should be asking for?
Yeah, my wish list would be to keep the patient and the human not separate. So that would be on top. I would also have you know, the electronic e-signature for consent, you know, so again, it's all on there. Also, you know, if the human, you know, the client has agreed to marketing, I would record that consent on the record with a stamp, you know, date and time. So I would have that. I would also have, you know, the fact that they have authorized someone else to act on their behalf if they are unable, and who the person is. So I will have them to do that, to sign that, and again electronically. That's what I mean, you know, on the actual system. Again, you know, if they are you know, the guardian of someone, you know, put on there all of the perhaps the copy of the guardianship document scanned and loaded onto the profile of the of the record. So that is, you know, what I would, the other thing that I would ask is, so when you are transferring from one vet to another, is you know, the human notes, they can be transferred in two ways. Either the human, so the client, so to submit a portability request to the current vet, and so to say, I'm asking you to transfer my human data to the new vet together with my pet's data. So you need to record that into the system. So I will record that. So that's one of the things. Or the other thing that if the new vet says, you know, we need to have your human notes as well, you know, do we have your consent to ask the old vet, again, to record that consent into the system, so that again, you've got it all there in black and white. If there are any disputes later on, if the current vet want to see proof of that, to say, well, here it is, you know, the client has signed their consent, you know, etc. So those are the things that I would have. The other thing, this is something that's happened to me. So I moved my dogs from one vet to another. So, and the old vet used to send me service messages, you know, to remind me of when my dogs were due for vaccination, etc. But the moment I moved, they should have stopped doing that, because one of the things that under the regulation is that you have to have a legal reason for processing the data. I was no longer the client, therefore they did not have any reason anymore to process my data. Now that doesn't necessarily mean that they need to delete my data, but they need to stop processing it, they need to stop using it. So they can store it and hold it in line with their retention policy and then delete it. But the moment I stop being the client, they should stop communicating, they should stop using my data.
Okay.
So I would have the system do that, so automatically.
Okay, yeah. So okay, so as soon as you've sort of, you know, you've hit a button, say I've transferred this client, and it should then sort of stop those sort of service records. That's good. And also, I guess sort of it would be useful if there was a like a auto retention on that. You know, you were talking about retention, how long you can hold on to that information. You've obviously got to keep it 7 years because you need your financial records and things, but presumably after that time, the option is either you're going to have to go in once a year and kind of delete everything that you've not seen for 7 years, or,
I mean,
or maybe you can get the system to do it for you.
So the rule of thumb, apart from financial, the rule of thumb and for employee data, but in terms of communication data, clients data, is 6 years. And that it's you can justify that under the you know, the Limitation Act, which basically says that if someone takes legal action against you, you have the right to defend yourself. But they, you know, and they only have 6 years to do that. So you know, the suggestion is to keep it for 6 years. You have the justification to do so, and therefore you can then program your system to automatically delete that data on the anniversary of the 6th year.
Great. Okay, so that would be a useful thing to be finding out from your PMS, wouldn't it? Okay, cool. Brilliant. Thank you. Right. Okay. I would like to understand more about exemptions we can use under SAR or DPA to withhold phone recordings, internal communications between vets relating to patients, but due to the client's name being revealed, the data then becomes released. Human doctors and solicitors are able to rely on legal or medical privilege exemption. So first, Christina, maybe you can SAR and DPA. Can you explain what those are? Okay.
So the SRA is subject access request. So this is one of the rights that as an individual we have under the GDPR, where we can ask for copies of our data. And then DPA, in that context, I think is the Data Protection Act, which is basically, the GDPR is part of the DPA, basically.
Okay.
So in terms of the, the professional privilege, the client privilege, that really only applies to solicitors. So you have to be a legal profession for you to use that, or a doctor, again, a human doctor, a doctor of humans. But animals don't have that privilege, so the answer would be no. There isn't such a thing in that respect. So I think that answers that question.
So if the is that right then, under the subject access request, where you've got a phone recording between vet A and vet B, if they say that that they are talking about Mrs. Jones's dog, does Mrs. Jones have is that right, that because her name is mentioned that she then has allowed to have access to that recording?
Okay, so are we talking about the recording? Are we talking about a subject access request? Because it's I think there is someone with a hand up. Daniel, can you allow Karen to talk?
Yeah, let's if you want to ask.
Hiya. So this is my question.
Okay.
We've had some requests recently from clients where they've under SAR, they've requested call recordings between us as the veterinary practice and another veterinary practice, because they know we record our calls. So on the calls, we'll be discussing the patient. So obviously I understand an animal is not covered under Data Protection Act. So we're mainly talking about the animal. However, at some point, obviously the owner has become identifiable, because we might talk about Karen Lister's dog called Fluffy and the certain treatment that's having, or the different courses of treatment, which would be the best. So we'll be discussing as two vets, just throwing around ideas of what's the best route, knowing that they know their client and maybe best for us, and we're looking at it from a referral point of view. When I spoke to the ICO about it, because we didn't actually on this occasion want to release the call recordings, the ICO said to me it's all about the data, and although you could argue it's personal data because the owner is identifiable, it all relates to, the word relates to the context of that conversation, what harm could be done, and they sort of guided me that we should share the data. And I said, okay, well, what about the argument back is it's too do I need to get permission from the other vet because it's kind of their third party data? And they was like, well, no, because they're acting in a professional privilege. So although it's their voice and their name, their practice is identifiable, they couldn't really withhold it under the personal data. So I was just really asking, is there an exemption? Is there a way, or how can I interpret the word relate to not be able to release that data?
So the first thing that I would ask, Karen, is what is the purpose that you are recording the conversation, internal conversation between two vets?
We record all our call recordings. So every call recording, everyone who rings in and out of our hospital, the calls just by default are recorded. So you could argue, then you'd say, if you're going to have maybe a difficult conversation, don't use a recorded phone. But I'd prefer not to start, changing policy. I'd rather just try to find.
So, I would be curious to understand the reason for recording all those conversations. Behind the policy of the organisation. What is it trying to achieve? But recording. Yes, it is personal. Obviously, again, the patient is the animal in that content. But obviously, you have two people talking, so those two people are individuals. If they're talking about the patient, and they might mention the name of the owner, but again, it's their data, it's the owner's data who's asking for it. So what you can do is that you can ask, if they submit a subject access request and they say, I want a copy of the recording, you can ask the two vets for their consent, okay, if you want to. But then ultimately it's up to you to decide whether the data is, you can disclose the data. The other thing that you can do is that you can redact the data. So there are very edit software where you can edit the audit, so you can remove the section where the vets are perhaps saying their own names, or they are saying something that would identify them, because it's not the owner that you want to protect, because they are the one asking for the copy, so they know they're going to be in the recording. It's the two vets that they are talking. If that makes sense, Karen. Hope that that does.
It does. It's more just the nature of the conversation. Like, it's more, I don't want to release the recording. So is there a way, because it's mainly talking about an animal which is not covered by data protection, that I can
so
say,
you can refuse.
okay,
Justifying that it is about the animals. You have as long as you justify it. However, if they keep insisting and they want a copy, at some point you might have to release it.
okay, thank you.
So
Yeah.
presume, I think what they were in that conversation, is just having one, the client's name, Mrs. Jones, and obviously you might mention Fluffy as well. But does that make her clearly identifiable? Because you're probably not saying Mrs. Jones of 5 Windsor Avenue, are you? Is just the name, is that enough to count as personal data, Christina?
Yes, it is. Your name is personal data.
Okay, even if it's on its own.
Although the conversation is primarily about the animal, Fluffy, but if the name, Mrs. Jones is mentioned, or something that she could be identified, that is personal data.
Okay.
So, but for example, it could be that they're talking about Fluffy, and then they say, please, don't make sure that you don't give to Fluffy any live vaccine because the owner has some immune system issues. That is vague, that is anonymized, it doesn't identify the individuals. So, that is not personal data in itself, if that makes sense.
Yeah, no, that's good.
I hope, Karen, that answers your question.
We've also had a message in the chat, Christina, from Lisa, who is also from the same organisation as Karen, I think.
Okay.
And she said, because you were asking about why they needed to record the conversation, and she said that they record the phones for multiple reasons: training, consent for treatment, etc., and supports our complaints. So I guess that would be if the conversation's been had between the vet and the client, and the vet had said, well, we can do this procedure, and it's going to cost you £5,000. Then and Mrs. Jones says, yes, I want you to do that. Then they've got that recorded, even if Mrs. Jones hasn't come in and signed a bit of paper, I suppose. So.
Yes. So yeah, that's fine.
Yeah,
I was just
lovely.
I just wanted to understand the purpose behind the recording, which makes sense. Yeah,
that's good. Yeah, but it is worth, obviously you sort of mentioned that anywhere where you're collecting data, you can do it, but you've got to have the justification for it, haven't you? Yeah,
and you've got to, and as I said, so the more data you collect, again, the higher the risk. But also, the more complex subject access requests are going to be, because then you've got more data to put together, to give out, and to redact potentially. So, so you've got to sort of balance, the pros and cons of recording those conversations. If the cons are higher than the pros, then go ahead. Sure.
Well, with that, I want to check in and see how many more questions we have, just as an idea.
I'm on my final question.
Oh, look at that. Okay.
Perfect.
Then I say, we'll do our final question.
We'll do that one.
We'll begin wrapping it up.
Okay. So, this is just, so I'm not sure this is all entirely GDPR, but it kind of goes to GDPR at the end, Christina. So how would you deal with negative feedback on social media or the internet where vets are named in full so that they are clearly identifiable, and where the review or the claim is inaccurate? Do they have a right of erasure? So that's that's the vet themselves. So have they got the vet got the right to say that's got my name in it? I want that removed.
So the right of erasure applies to every individual. So we all have that right. So in this scenario, the social media is what the GDPR defines as the controller. So they would be the one where you would ask for the data to be deleted. Now they can refuse because the right of erasure is not obsolete. So they can refuse. You know, and you know, obviously they have to justify that. But you would also need to, again, this is the non-GDPR aspect of it, is that you would need to, you know, seek sort of outside, you know, data advice, you know, legal advice with regard to defamation, because obviously, you know, the comments are, you know, negative and defaming your reputation. So, but that, you know, it's a different legal.
That's not GDPR, but
yeah.
Okay, fab. Well, that was my last blue card, Daniel.
Great. Well, I'm glad that we were able to get to everything. And I'm seeing most of everyone is still here. And so I thank you very much, everyone who came to join in on this and have your questions answered, and to learn a little bit more about GDPR. And so I'm very glad that we could have some of the best people in the industry to discuss this. And I want to put in the chat right now some helpful links if you want to follow up. I'm going to give Laura's, as long as you both are okay. Speaking of data privacy, Laura, Christina, yes. If I may.
Very happy for you to put details there.
Okay, so I'm going to put your LinkedIn's and mine, and then I'm going to link Celeritas, our website for the past and upcoming webinars. So that you in the audience can join more conversations like this, or check in on some of the conversations we've already had. But with that, I just want to say thank you so much, Laura and Christina, for joining in on this and for sharing your knowledge. And I loved the back and forth format, kind of the Q&A. That was great. I really appreciate everyone who submitted questions. You helped keep this active, and I would love to continue this conversation soon. So stay connected on LinkedIn, and we'll check in with everyone on what were some of your favorite discussion points and moments from this. But with that being said, I'll give Laura and Christina the last words if they'd like to say anything before we head out.
Yeah, thank you very much. Thanks very much for hosting us, Daniel. It's been absolutely super. If anybody wants to find out about Training Progress and our process and training management platform and how that can help you to manage your GDPR processes and your GDPR training in your veterinary practice, then do reach out via LinkedIn, and it'd be super to speak to you and find out about your practice. Christina?
Yes, stay with me. So thank you very much, everybody, for taking part and asking really interesting questions. I really enjoyed this. Thank you for having me, Daniel. And you know, if you have any questions, or if you would like to know more about GDPR, or what tools I have available for you, invest in the toolkit, which Laura uses as well. And you know, do please get in touch. It's packed with documentation, videos, also include monthly surgery, so you can actually tap into me every month if you have questions. Do reach out, and yeah, love to speak to you.
Wonderful. Okay, well, with that, everyone get those links copied and pasted into your notes. I'm gonna once again give a big thank you to our two facilitators, Laura and Christina, and to the audience here today who helped join in on the discussion with some of your questions. And thank you very much. I hope everyone has a great rest of their day.
Super. Thank you. Good evening.
Thank you.
See you.